Thank you, Senator Blumenthal, and I'd like to thank the entire panel for your service to our nation, for your testimony here today, and for your hard work to make sure that we really focus on and get right some of these tough questions. Just to follow up on the exchange that just happened, if you might, Professor Swire, how did the review group's suggestions surrounding the Section 215 authority address the constitutional concerns that were raised by Judge Leon? If you could just focus us on the outcomes.
Thank you, Senator. Our task that we were asked to do was not focused on constitutional analysis. Our task was on what policy should be going forward. So as a group, we did not try to make an assessment on the constitutional issue.
But in your view, do the group's recommendations actually address some of those concerns or fail to address them?
Well, we tried to do the task we were assigned. I think that, as Professor Stone was just saying, there's discussion in the report about how metadata looks given changing technology. And so in the 1970s, there were a limited number of phone calls. Today, the number of texts and Facebook posts and everything is enormously different. And that kind of difference is the kind of difference that 5 justices of the Supreme Court referred to in the Jones case. So we asked for a study, among other things, on these metadata issues because we think that the changing facts require some changing law probably, but we don't say on the Constitution what our view is.
Mr. Morell, if I might, the review group recommends replacing the Privacy and Civil Liberties Oversight Board with a new Civil Liberties Protection Board. And this new board would be empowered to review the privacy implications of all counterterrorism and foreign intelligence collections and have a new function to respond to whistleblowers and have new investigatory roles. The current PCLOB is, I would suggest, absurdly under-resourced relative to its scope of responsibility. The president's budget request includes only I think it was $3.1 million for the PCLOB. I may be wrong on that. Authorities without resources can be worse than no authorities at all because they provide a false sense of security. I would be interested in your view of what budget would be sufficient to allow this new board to perform its mission.
So I don't have a specific answer for you. That's not something we looked at, but it would be significantly more resources, in my view, than it currently receives today.
Well, the Intelligence Community Inspector General, just to continue the examination, ostensibly exists within the IC to ensure legal compliance. And it recently told us that it lacks the resources to conduct a thorough and full review of the 215 metadata program by the end of next year. So I think that reinforces the point that some significant increase in resources is needed to ensure the sort of oversight and accountability that I think all of us are working together to ensure. Mr. Clark, if I might, declassified FISC opinions have revealed that the NSA in the past exceeded court-established bounds of the Section 215 bulk metadata collection program routinely and attempted to defend those actions in front of the court. I think it's widely now agreed that this was a violation. Some of us would allege a serious one. My concern is that the NSA initially tried to defend its use of non-approved selectors, and I'd be interested in your view about why the NSA attempted to defend its illegal actions as legal and what reforms are necessary to encourage the IC to come clean and admit its mistakes in cases like this.
Senator, I think there was a good faith lack of understanding and lack of communication between NSA and the court. I don't think there was any intentional attempt to circumvent the court, but I think we had a bunch of engineers and computer scientists at NSA talking to a bunch of lawyers at the court. And I think there was a lack of understanding about what each side was saying. I believe as soon as the NSA learned of the court's objections, they rectified the problem. So I think what this points to, these incidents point to, is the need for the court to have more technical staff and resources. Just as the P-Club, as you mentioned, is grossly under-resourced, so is the court.
Are there any other elements of your recommendations that would deal with this cultural mismatch, at least as you suggested, you've got engineers and lawyers? Anything about adding an advocate to adding a more adversarial component to the deliberative process? Would that also strengthen the court's capabilities and oversight?
I think there are 4 or 5 recommendations that do that. One is a public advocate in the court. Another is strengthening the technical ability of the court staff. A third is creating in the new Civil Liberties Commission a technology assessment staff.
The review, if I might, Mr. Clark, my last question. looks at two authorities, Section 702 and Section 215. And these are both sections about which there's been a lot of public debate and discussion. But the review group also recommends greater government disclosure about these and other surveillance authorities it possesses, but the report appropriately and understandably does not itself disclose any additional programs. What review, if any, did the group make of undisclosed programs, or could you at least comment about whether lessons learned from such review is in fact reflected in the report?
Well, I think there's a great deal of metadata collected by the National Security Letter Program, and we do speak to that in the recommendations. There's also a great deal of communications related information collected under the Executive Order 12333. Public attention is focused on 215, but 215 produces a small percentage of the overall data that's collected.
Thank you. Thank you to the whole panel for your testimony. I see I'm past my time.